What movies and TV shows get wrong about the law? Most questions lawyers ask witnesses on TV and the movies would not be allowed in a courtroom. Everyone has probably at least heard of the movie A Few Good Men, where Tom Cruise is questioning Jack Nicholson in a military courtroom.
You want answers?
I think I'm entitled.
You want answers?
I want the truth!
You can't handle the truth!
He gets to the point almost where he's badgering Jack Nicholson as a witness. He keeps asking him the same questions over and over again. He keeps asking them in different ways. And the point is he's trying to get Jack Nicholson to admit that he ordered the code red. We've all seen, or at least heard of that scene. And if you haven't, you should watch it because it's great.
Did you order the code red?
I did the job.
Did you order the code red?
You're goddamn right I did!
However, it's not the way the law works. There's actually no Texas rule against badgering a witness, but what a judge can do is can stop a lawyer, either a prosecutor or a defense attorney, from questioning a witness in a way that's harassing them. And if you watch that scene in A Few Good Men, I think you would agree that that's probably harassing.
You made it clear just a moment ago that your men never take matters in their own hands. Your men follow orders or people die. So Santiago shouldn't have been in any danger at all, should he have, Colonel?
You snotty little
That's a good example of something that would be allowed in Texas courts. Tom Cruise and the way he's questioning Jack Nicholson is harassing him.
Call the surprise witness.
There's no such thing as a surprise witness. We've seen that in movies over and over again. At the last second, the attorney brings in a witness and there's a hush in the room. The attorney on the other side starts shuffling papers and looks shocked and doesn't know what he's gonna do. Well, you can certainly try that in a courtroom. You can certainly try to bring a surprise witness, but a judge is never gonna allow it in. Usually beforehand, or always beforehand, there's some type of pretrial hearing, or at least there's pieces of paper that have been filed with the court with each party's witness list. The purpose of that is so the other party can at least prepare for or know what's coming. Now, you don't have to reveal your strategy to the other side. There are always ways to surprise the other side with the type of questions that you may ask a witness, but you can't just call a random person at the last second in an effort to try to win your case without telling the other side in advance.
Miss Wyndham, had you ever gotten a perm before?
Yes.
During a trial, an attorney, whether he's the prosecutor or defense attorney, cannot walk around the courtroom whenever they want to. Most of the time, questioning is done at one of the tables. If you want to get up and talk to a witness or walk up to a witness while you're questioning them, you have to ask the judge for permission. And I'll tell you right now, if it's a federal case, the judge is never going to give you permission to step behind a podium to walk up to a witness to talk to them, unless in certain situations you're talking about a certain piece of evidence. But if you're just asking them questions, that if you can ask the judge all you want, may I approach the witness, the judge is going to say no. And that's the way it is in a lot of state courts as well. The judge wants you to sit at counsel table and ask your questions to the witness at counsel table. Now, there are certainly exceptions. If you need to demonstrate something for the jury and you can do that better with the witness, then sometimes the judge will allow you to walk up to the witness.
Now, we can do something about it. We can do it today, and we can do it together.
You can never get up in a juror's face and argue your case. It's just not gonna happen. Attorneys walk up to a jury and stand very close to them and put their hand on the rail and lean into the jury. That never happens. First of all, you're invading their personal space. And secondly, it's just not proper argument.
I need your help.
Anyone who's been stuck in the mud in Alabama knows you step on the gas, one tire spins, the other tire does nothing.
That's right.
Is that it?
No, there's more.
And finally, one of the most irritating things that I notice in movies and TV shows is you'll see a lawyer questioning a witness. And while they're questioning the witness, they'll either turn to the judge or they'll turn to the jury and they'll start making an argument based upon what the witness is saying. That violates a lot of different rules. It violates a rule of procedure where you can't make an argument while you're questioning a witness because the witness is the person testifying. It's your job as an attorney to ask the witness questions. It's not your job to be testifying to the jury or the judge why a witness is testifying. That's improper. It's also improper to start taking whatever a witness is saying piecemeal and start making arguments to the jury or the judge. If you begin doing that, and attorneys do that sometimes just because they're passionate about a case, a judge is going to shut them down immediately. You can't go on into argument while you're questioning a witness. There's a reason why trials are set up in a certain way. You have your opening statement, then you have a portion where the prosecutor brings their evidence through witnesses, then the defense, if they choose to, can present evidence to the jury. And then after all that is said and done, both sides get to make their argument to the jury. But you don't get to argue to the jury or the judge during the middle of a case or a trial.
You're out of order! You're out of order! The whole trial is out of order! They're out of order!
If you have any questions about what I talked about today, leave a comment below, or you can visit our website at versestexas.com.